the association. Good morning, Mr. Cheriton. I will start with, if you allow me, with Mrs. Beaver on behalf of the National Association of Women in the Law. Mrs. Beavers.
Thank you and good morning. Thanks for the opportunity to speak on this bill on behalf of the National Association of Women in the Law. I'm also pleased to be speaking today on behalf of Luke's Place, our sister organization with whom we've worked in partnership on Bill C-78. As I think you all know, NAL is an incorporated not-for-profit feminist organization that promotes the equality rights of women in Canada through legal education, research, and law reform advocacy. And indeed, NAL has been around since 1974 and advocating for the much needed changes to family laws, including the Divorce Act, has been a focus of our work since the early 1980s. NAL and Luke's Place developed a joint discussion paper and a brief on C-78 that reflect an intersectional feminist analysis of this bill, which was submitted to the House Committee and that I believe was also made available to all of you. Our joint brief was endorsed by 31 organizations from British Columbia, Saskatchewan, Manitoba, Ontario, Quebec, and New Brunswick, as well as more than a dozen national feminist and equality-seeking groups. And it is the fruit of our consultations convened with feminist academics, lawyers, service providers, and advocates. And I raise this now simply to emphasize that there's broad-based support for many aspects of Bill C-78. And we urge this committee, the House, and the Minister of Justice to cooperate to ensure that the bill is passed before the end of this parliamentary session. We take this position as Bill C-78 introduces many important and long overdue amendments to the Divorce Act, including placing the well-being and best interests of the child at the center of the bill, developing clear criteria for the best interests of the child, the clear identification of family violence as an issue that must be taken into account in divorce proceedings. The inclusion of coercive control, psychological, financial, and animal abuse in the description of family violence is very important. And recognizing that family violence exists whether or not conduct constitutes a criminal offense is critical if women who are the primary victims of abuse within the family are to receive appropriate outcomes in divorce proceedings. And I want to emphasize that NAL fully supports the exclusion from this bill of any presumption of shared parenting. Determining what is in the best interests of a child must be done on a case-by-case basis. I'll come back to this point and make some recommendations for amendments to clarify this critical issue. But in the hopes that all parties involved can cooperate to make just a few key amendments to this bill, NAL and Luke's Place propose the following 4 key and relatively simple amendments that can be made to C-78, which reflect concerns raised by a range of the briefs that have been submitted both to this committee and the House Committee, as well as the testimony of witnesses, including today and yesterday. And these are all focused on family violence issues in the context of divorce. Our first recommendation, which was also supported by witnesses yesterday, and I believe this morning as well, is that Section 16.6, entitled Maximum Parenting Time, be deleted entirely from the bill. This provision opens up the possibility that maximum time with both parents will be presumed to be in the best interests of the child, which, as we know, is not always the case, especially in the context of family violence. This clause could seriously undermine the entire framing of this bill around the best interests of the child as the primary and indeed the only presumption that should be in operation in divorce proceedings. Our second recommendation is that Section 16.3c also be removed from the bill. In cases where there has been any family violence, it is totally unacceptable, and indeed in many cases it is dangerous and even lethal to insist that a mother be willing to support the development and maintenance of the child's relationship with an abusive spouse. Similarly, Section 16J1 should be removed or revised, as the critical issue to be determined here should not be the willingness of an abusive parent to care for a child. The focus should rather be on the impacts of family violence perpetrated by that parent on their capacity to parent, not on their willingness to do so. in a manner that reflects the best interests of the child. Our last recommendation is that the bill should explicitly reflect the reality that we were very pleased to hear the minister acknowledge in his remarks yesterday, which is the gendered nature of family violence. Now, the evidence on this is clear and unequivocal. As with other forms of gender-based violence, the majority of victim survivors of violence within marriage and when it ends, and I emphasize this, are women, and men remain overwhelmingly the perpetrators of this violence. Therefore, as reflected in recommendation number 3 contained in our joint brief, we recommend that the gendered nature of family violence be included in the bill by simply adding to the definition that's already there of family violence that family violence perpetrated against women is a form of violence against women. We've also provided a definition of violence against women that can be included as well, and this is found in recommendation number 2 in our joint brief. However, given the short timelines that remain to agree on any amendments, I can also propose a second globally agreed and long-standing definition of violence against women that could be adopted at this point and then reviewed later when the Divorce Act is next reviewed, which we hope will not be with the same delay and length of time that we're now facing. In conclusion, I reiterate that while concerns with these elements of C-78 remain, I'm here today to urge you in the strongest possible way to pass this bill. Bill C-78 offers the opportunity to modernize the Divorce Act so it better reflects the realities of families in 2019. And in particular, it will be able to more appropriately and effectively respond to families where violence is a reality, making it possible for women who are the primary victims of violence and their children to move on to lives free from violence or the threat of violence. The Divorce Act, as amended by C-78, can protect the best interests of the children, understand family violence, reduce child poverty, and increase access to justice for families in Canada. I thank the committee again for providing Noel with the opportunity to appear on C-78.
Thank you very much, Mrs. Beavers.